The Supreme Court of India recently ordered the Haryana government to come clean on all the sale deeds that have been executed in respect of the 1400 acres of land that it wanted to acquire in Gurgaon in the year 2009. This 1400 acres now comprises of the luxury premium sectors of Golf Course Extension Road, which have come under the Apex Court scanner for misuse of the land acquisition process. Is this the precursor of a long legal battle? How is this going to hit the investment of home buyers in these sectors? And what really is the inside story? Vasudha Sharma delves deeper.
These high-end residential projects on Gurgaon's Golf Course Extension Road are under the scanner for being a case of land grab rather than acquisition. The Haryana government in 2009 announced its grand plans to acquire a contiguous 1400 acres to develop 9 new residential and commercial sectors from 58 to 63 and 65 to 67. Instead, the government invoked its powers of eminent domain using the 1894 Land Acquisition Act to artificially prop open the agricultural belt of 8 villages of Gurgaon for distressed land deals.
There was a fear created among the farmers that their land would be acquired and they didn't know what to do. At that time, builders approached them and entered into various agreements with them, on the basis of which they have applied for CLU with the government, and the government under its various policies have released the lands on which an agreement was there with the builder. And in the end, only 85 acres from 1400 acres left. That is why we in our petition have taken a stand that this acquisition was done primarily to help the builders.
The Punjab and Haryana High Court in its January order this year had also presented as evidence how 94 licenses were issued to private builders right after the state government had announced its acquisition plan. So while the acquisition of 1400 acres never took place, the state government later acquired 87 acres of scattered land parcels across 8 villages of Gurgaon, stating the public purpose of providing public utilities. But petitioners allege the sectoral plans have been tailor-made in such a way that these public utilities only benefit the private builder projects, thereby defeating the whole public purpose argument of the state government. Today, on some 1300 acres of that proposed land parcel, premium projects are being developed. And on land totaling just 85.9 acres, the state government is planning public amenity projects like a hospital, police and fire station, etc. Petitioners allege the state government's claim that it's obligated to execute external development works are misleading and farcical. The Haryana Development and Regulation Act 1975 clearly states that either the builder has to compensate the government or provide land from its own holding. Land taken in the name of public purpose cannot serve private interests. So what happens to the real estate market that has spawned over the 1400 acres? When contacted for their comment, 2 of the developers had this to say: land for all IREO projects in Gurgaon has neither been transferred or sold by the government to IREO, nor has it been acquired by IREO under government acquisition proceedings. The said land was purchased privately at market rates. The MRMGF spokesperson said that projects being developed by MRMGF are not affected by the order. The project land has not been purchased through any sale deed executed after the initiation of the Section 4 proceeding. The counsel for the petitioners fighting this case clarifies that the legal tussle that hit headlines is only being led by landowners from these 85 acres who want their holding to also be freed from acquisition. Everything else stays as is. The projects that have come up are private deals between farmers and builders. How they were galvanized may have been acknowledged by the court as malified and a colorable exercise of power, but all those private residential projects are out of this case's realm.
The issue before the court was only as regards 85 acres. The rest was status quo. The rest was never challenged. Whatever the land has come to the builders rightly, wrongly, by whatever way, that is not challenged before the High Court. The High Court is not dealing with that.
So while this clears the air on all those multi-crore investments by home buyers, the larger issue is how the government's role as a facilitator for land development seems to have turned into that of a land grabber. In Gurgaon with camera person Nitish Atri, Vasudha Sharma, NDTV.
A leading newspaper reported that in the 23 years preceding Mr. Huda's rise to power, successive chief ministers granted licenses for just a total of about 8,500 acres. But during the 7.5 years that Mr. Huda has been the chief minister, licenses for the development of a staggering 20,000 plus acres of land have been granted, to private developers. That's an increase of nearly 150%. Clearly, lines are getting blurred between government's role as a land aggregator and the government as a grabber. Today, I have with me Jagan Shah, Director, National Institute of Urban Affairs, and Chetan Agarwal, activist and environmentalist, to run us through what's really happening. I mean, this story, Chetan, is not unknown. Everybody knows about it. Recently, we had a big decision by the High Court cancelling the 350-acre land allotment to DLF, and the 1,400-acre that Vasudha just highlighted in her story. Again, big question mark on how those negotiations happened, and literally it seems that the government fooled the farmers into believing that they should quickly negotiate with private developers and give away the land. So, will it stop with the new Land Acquisition Act, or more needs to be done?
Thanks, Manisha. I think fundamentally this is a planning failure, that areas which should be developed need to be identified and areas which should not be developed need to be identified. And the increase in value which comes as you shift from agriculture to urban real estate should be shared fairly amongst the stakeholders, and especially the farmers and the government and the developer, if there's a developer involved. But unfortunately, as the numbers you're showing suggest, that basically a big share of the cake has gone to developers, and at the receiving end are the poor farmers who had to sell the land cheap under coercion of the Land Acquisition Act in one case, or the land was acquired by the government and then passed on to the developers, as in the 350-acre example.
Okay.
And the environment is the loser in all these situations, because if individuals go and buy small pieces of land, then that's the only land they have. They want to develop it, whether it's environmentally sensitive or not. But if the government does it on a large scale and they do it before the land is purchased and the master plans are made, then people know that this is the area which is to be conserved and this is the area which is to be developed. And they focus on the developable area rather than the area to be conserved.
Jagan Shah, I mean, National Institute of Urban Affairs, you must have studied the Gurgaon story several times over. Planning, what are we talking about planning? There have been 3 master plans in 6 years. So clearly no one can make up their mind, and everybody wants it to remain nebulous so that, you know, these can be, norms can be flouted, or there are no norms, so it's a free for all, isn't it?
Well, I wouldn't say that it's a free-for-all as such, and I certainly wouldn't say that the government is the villain of the piece. I think this is a like many other things in our country, this is a larger collective failure of creating a system where we are not allowing people who own the land, the people who actually reside in a place, to have the right to make decisions about how their land is used, what kind of value is applied to their lands. And that ties up with what Chetan has just said about planning, where even though we have a constitutional amendment made in 1993 to devolve the powers of all development decisions to the local authorities, we still have not instituted in letter or spirit this kind of an amendment. So we are in a sense perpetuating and consolidating the alienation that India's people have from their primary capital asset, which is land.
Do you think the new Land Acquisition Act fixes that? So now there is a formula, there is a pricing formula. Even a state government acquiring land for so-called public purpose will have to pay that price. Is that the answer? Or, you know, again, we have a finance minister talking about diluting that act. Instead of 70% people giving the consent, it's only now 50%. Of course, those are for large projects. But even just the pricing formula for small parcels of land, do you think it will protect the interest of the farmers?
Well, it tries to make a move towards protecting the interests, but again, it does so on the basis of somewhat questionable logic, like food security and such like issues. In a survey done by the National Sample Survey Organization some years ago, they discovered that about 40% of the landowners out of this sample group wanted to sell. They wanted to leave their agricultural lands and probably become more assimilated into the urban system. I think the Land Acquisition Act that has been introduced is overly harsh, and it actually creates a further distortion because it in a sense becomes like a preventive for any kind of land transactions. And in an ideal scenario, you should actually facilitate land transactions, but leaving the prerogative of selling land and assigning uses to it to local residents.
Okay. Chetan Agarwal, what's your own view? I mean, one is of course planning and zoning, which is critical. Once that happens, then the room to actually do deals which are not above board or above par gets reduced. But overall, if you were to look at Gurgaon today and say, now is there enough information amongst farmers not to get worried about their land getting acquired? And do you think that in this case where 1400 acres, because of the fear mongering which the government created, has already gone to private developers at a very, very cheap rate, can that now be overturned? Because the High Court has not ruled in that favor. They've only looked at that 86 acres.
I think it will be useful to look at the coal allocations decision from the Supreme Court and maybe apply a similar principle here, that areas where the mining has already started, they have to pay some kind of fine maybe, and the other areas where they haven't used the land, the license was cancelled. So a similar approach could be applied in this kind of situation if it can be shown that these guys moved in to buy the land after the notification of acquisition was put in place,
okay,
which suggests that either they were really real risk takers, that they felt that the government might change their mind, because otherwise they would lose money, because the acquisition rates at that time were probably very, very low.
They were.
Or they knew something which the farmers didn't.
All right, so there could still be some hope and respite. Jagan Shah, Chetan Agarwal, thank you very much, gentlemen, for making the time. It is quite an important issue and we will keep highlighting, and of course in this case all that we can say is the existing projects are all safe on golf course extension, but those which are not yet built, well, Supreme Court with its activism, courts are willing to take a look at all the deals which have happened which are probably not fair, take a relook at them, and we don't know what could happen. Thanks very much, gentlemen, for joining me today.